Hello and welcome to part 3 of our Synergenics webinar series. Whether you're joining live or catching the replay, thank you for being here. We're pleased to collaborate once again with Providence CPAs to bring you this session on estate planning for healthcare providers. Today, Todd Hudgins will be leading this presentation. Todd is a certified public accountant and licensed attorney in Oklahoma, Texas, and Arkansas. Todd's been actively practicing law since 2001 and is the founder of Horizon Attorneys and Counselors at Law. Todd formed Horizon to offer clients a unique legal experience and has been helping them navigate estate planning for nearly 2 decades. We're thrilled to have him share his insights with us here today. Before we dive into the content, I'll let David Auer introduce the rest of the panelists. David, the floor is yours.
Thanks, Sean. So I'm David Auer, founder of Providence CPAs. Hopefully everyone on the call has watched the webinar that we did a couple of weeks ago on tax planning or the tax updates and the changes that are going to potentially happen depending on who gets elected in office. If you haven't watched it, I'd encourage you to go back and watch the recording and just be prepared for the elections that are coming up next week. And then also, hopefully you also had a chance to watch Bill Bennett on our previous webinar talking about mitigating financial risks. And then those of you who were on the previous calls, you also had a chance to meet with or see Angie O'Day. She is our client success manager, and generally she's the first person that somebody would talk to about finding out more about how we might be able to help you. She's not on today's call, but she'll be. I'll share her contact information at the end of the webinar. So just FYI, we've got one more in the 4-part series coming up next Tuesday, the 5th. Kind of an interesting day to pick to do a webinar, but we're going to be talking about the private insurance advantage. So this is a new strategy that has only been out for a couple of months, and we combined a couple of unique strategies out there to come up with one that a lot of our physician clients are very interested in knowing more about. So feel free to join us, or at least register for it so you can watch the recording afterwards for coming up November 5th at 4 o'clock Central. Just real quick before we jump into the presentation, just want to share that everything we're going to talk about from a tax standpoint is within the 4 corners of the tax law. Nothing that we're going to talk about is pushing the envelope. So just so everyone's peace of mind, some of these things you may not have heard about, but certainly these things are very legal or are fully legal, and you should work with an expert to make sure that it's done correctly. So the agenda for today is we're going to first talk about our version of a definition of estate planning, and just hopefully everybody will agree that it meets their definition. Talk a little bit about why estate planning is important. Go over some basic estate and asset protection strategies getting a good foundation in place, and then talk a little bit more about advanced estate and asset protection planning, and then we'll open it up for questions and hopefully provide some answers. So with that said, Todd, I'll turn it over to you.
Great, thanks, David. Thanks for joining us, and I hope you guys get something out of this. The main thing is that I hope that I can stress that estate planning is important for everyone. I think a lot of times people feel that estate planning might be for only old people or perhaps for very, very rich people. But I hope after today's presentation, everyone will realize that we all need some type of estate plan. Yeah, Dave, if you want to switch to the next one, where I like to start is just how we define estate planning. And really, if you think about estate planning, it's really just in its simplest form, it's giving what you have to the people that you want it to give it to, when you want to give it to them, in the way you want to give it to them, and all while minimizing the cost, right? So none of us want our people or want the people that we love to fight over what we've gained during our lifetimes, and we want it to go to the right people. And we don't want to have to pay attorneys to do that, hopefully. So to accomplish that, you're going to need a good estate plan. And so we all need one. And if you don't have one, newsflash, the state has one. Whatever state you live in, the state has a default plan for you. And I promise you, you will not like the state default plan. So hopefully that's encouraging to all of us to get out there and get an estate plan, put it in place. None of us know when we're going to go. And so we've seen lots of situations where people wait too long and then they're unable to do it, because you do have to have some mental capacity to be able to put your plan together, right? You have to know what you own and who you are giving it to. So we talked a little bit about the intestate, but that's just basically if you die without an estate plan, you die intestate. And a huge issue in Oklahoma, in some states it might not be as big of a deal, but in Oklahoma and a lot of the states across the country, it's a huge deal to have to go through the whole probate process. If you don't know what probate is, it's not fun. It's a court-driven process in which you get to hire a lawyer. You get to go before a judge, get someone appointed as a personal representative, get your will admitted to probate. They publish the notice of the hearing in a paper for a week or so. And then you get to wait about 90 days for any potential creditor that might be out there to come file a claim against your estate. And all this time, you're actually getting back on the docket too. So at least in Tulsa, Oklahoma, our dockets are pretty crowded. So it can take anywhere from about 2 to 3 months to get on the docket originally. And you're going to have at least 2 hearings during the course of your probate. And you're going to have at least a 90-day waiting period. So probate generally takes about a year to get through in Oklahoma. And as you can see on the slide, it often costs between 3 and 8% of the gross value of your estate. So do that math, right? Do that math and just figure out, I promise you, it'll be a lot cheaper for you to put a very good estate plan in place than going through probate. I get clients sometimes that say, hey, I won't care, I'll be dead. That's true, you will be dead, but the people that you leave behind might haunt you for the rest of your life if you make them go through probate. So hopefully you're not going to do that. You're going to take some time and take our advice and get out and put it on your checklist, get your estate plan in place before the end of the year. As you can see on this side too, you can have many potential unintended beneficiaries if you don't have your plan in place. Some of them that we mentioned here, the decedent's surviving spouse, descendants, children and grandchildren. These are all the people that you probably want it to go to, right? Your surviving spouse, your descendants, siblings, nieces, nephews. But if you don't have a plan in place, oftentimes it can go to people that you don't want it to go to. It can go to that ex-spouse. It could go to maybe kids that you don't want it to go to, that have spending problems, that have drug problems. And so sometimes you need to put these guardrails up to make sure you protect your beneficiaries from themselves. And so let's talk a little bit too, Dave. Can you flip the next slide for us? We can talk a little bit about taxes. Taxes, estate planning used to be fun when I first started practicing estate planning. The exemption amount that you can see here on this slide was $675,000. So we got to do a lot of cool estate planning, and then Congress took away all our fun, and they made the exemption so much higher. So now the exemption amount is $13,610,000 per person. So it affects relatively few people, the estate tax, that is. If you do have that problem, I would encourage you to seek out a good estate planning attorney. Every one of them will want to talk to you if you have a estate larger than $13 million, or if you're married, $27 million. Congress is always messing with that exemption amount. And in January 1, 2026, it's scheduled to go back down to $5 million index for inflation. So most people think that will be somewhere around $7 to $7.5 million per person. So you guys probably know about the basis step up when you die. If you bought Apple stock when it was trading at $5 a share, and you own a bunch of it, you might want to hold on to it until you die, because you get a step up in basis when you die. That means the stock becomes the fair market value. Your basis becomes the fair market value at the date of your death. And so that gain will basically just disappear. That could be the same thing on appreciated land, on a business, any of those types of assets. It might be wise to hang on to. And then we have the capital gain rate. That's 20% currently, unless you get hit with the 3.8% surcharge. So you could be looking at between 20 and 24% capital gain tax. Another thing to look at is just how your property is titled. That's very important. And even if you have an estate plan, it's very, very important to make sure that you properly align your assets with the plan. And sometimes we call that funding, but that's really just lining up your assets with your estate plan. And so it's always a good exercise to go through all of your assets, understand who the owner is, understand who the beneficiary is, and make sure that those are the way you want them to flow. Okay. If you die or if you have a disability, you want to make sure that you have everything titled properly. And so something I just encourage my clients always, at least once a year, to go back through all their assets, because I know people's assets change and their family changes, and you want to make sure you have that ownership and the beneficiary designations proper. You guys might have heard about this, but Dave, you want to tell a little bit about your favorite two people, Cornelius and Mayor Rothschild?
Well, one of them's my favorite. The other one was it's unfortunate, but yeah. So just a quick history. Cornelius Vanderbilt, at the time he died, he was the richest person in the world. He died back in the 1870s. He'd built his wealth in railroad. And he had about $110 million net worth, which was a lot of money back then. So he was a little bit philanthropic. He gave about $2 million to a small college called Central University that changed their name to Vanderbilt University that we know of today. The rest of it he gave to his wife and children. Interesting story. About 100 years after that, the Cornelius or the Vanderbilt family had a family reunion where all the Vanderbilts came together. And what was surprising is there wasn't a millionaire left in the group. All of the money had been dissipated or spent over those 5 or 6 generations since Cornelius had passed away. Mayor Rothschild, on the other hand, he passed away several decades earlier. He was a very well-known, very successful banker in Europe. He had 5 sons who were also bankers, and he sent each one of them to a different capital to establish a branch. So even though he was a commercial banker by training or by trade, he also had created for his estate planning what he called a family bank, which was more of a conceptual bank, not a bricks and mortar. And he had 3 simple rules to this family bank. The first was that if you were a member of the Rothschild family, you could borrow money from the family bank, but you had to repay it. So if you wanted to borrow it to go to school, you could. If you wanted to start a business or buy real estate, you could borrow the money, but you had to pay it back. The second requirement of the family bank was that every time you borrowed the money and paid it back, you were required by the family bank to share all of your experiences, both good and bad, with all the other family members in the Rothschild family, both horizontally with siblings, cousins, as well as vertically, aunts and uncles, children, grandchildren, nieces and nephews. And the goal there was to pass on that wisdom that had been learned by those individuals, so that every generation could learn from the wisdom that the previous generation had. And the third requirement of the family bank was that you were required to come back and share the family values every year with everybody else in the family. So you can imagine what's happened to the Rothschild family. Unfortunately, it didn't work so well with the Vanderbilt family, but the Rothschild family, as many of you may know, is one of the wealthiest privately owned banking families in the world. And they continue to just expand on that wealth as it goes from generation to generation by following those 3 simple rules. So very interesting contrast between 2 very successful families, one that had a really good estate plan and a legacy plan to pass on their values and their valuables, and the other one that didn't do quite so well.
Well, thanks, Dave. That's good. Super interesting. Well, let's look a little bit at the basics of a estate plan and asset protection plan. We can talk a little bit about foundational estate planning and what that really means. And I kind of have some thoughts and some opinions on what you need to have, but definitely, I think everyone needs at least a simple will, right? Even if you're just getting started, a lot of my clients are concerned about who would raise their kids. And so in that will, you're going to name who the guardian is. And that's even if you and your spouse can't agree, or you and your partner can't agree on who the guardian might be, it's a lot better for you to pick that guardian than for them there to be a court involved, right? You don't want someone and some judge making that decision on who's going to raise your children. So you can do that in a will. You can also pass your property in a will, right? But remember, the will goes through probate. And we talked about how most people want to avoid probate. So if you take the intermediate step and go with that would be a pour over will and a fully funded revocable trust. So this is kind of my favorite type of plan, is that most of my clients have a fully funded revocable trust, and that avoids the probate process. You'll see that we do have a pour over will on there, and a pour over will just says if we happen to miss something and we didn't get it properly lined up with your trust, it says, please dump it into my trust or pour it into my trust. So hopefully we're not using that pour over will, because if we are using the pour over will, it means someone screwed up. We shouldn't have to use that, but we do have it as a legal backstop just in case we need it. And then if you have either of these plans, either a simple plan with a will or a pour over will and a fully funded trust, you always have these other ancillary documents. And these documents are super important. Everyone needs a durable power of attorney for finances and property. And that's a document that basically just allows someone to make your financial decisions in the event that you cannot make those for yourself. And so that could be a disability, right? We get hit by a bus, we have some kind of medical condition that we can't make our own financial decisions. And we need someone to be able to access those, deal with our mail, deal with Social Security, all the things that we do on a day-to-day basis. We want someone to be able to do those for us if we can't do those on our own. And also, everyone needs a healthcare power of attorney. So you guys probably know what that document is, but just allowing someone to make healthcare decisions for you if you can't make those on your own. Things like course of treatment, administration of pain medication, keep me in my house or move me to a hospice. And then you'd also have an advance directive or a living will. And what that document is that really allows you to make your own decisions on keep me hooked up or let me go, right? If you have a terminal condition, if you have what they call an end stage condition, or you're persistently unconscious or in a coma, you can pick, do I want them to feed me artificially and breathe for me, or do I want them to just let me go? But it's super important documents. It's hugely important that you have these, that you have the originals, and that you probably make sure that some of your people that you've named in the documents have a copy of the documents as well. Dave, anything that you or Bill want to add there that you can think of?
No, I think, you'll bring this up in another slide or so, but it's the personal property memorandum, where a lot of times it's the things that aren't the most valuable, but they have the most sentimental value, that you also want to make sure that's included in that revocable trust.
No, that's a good point. And like David said, I mean, the personal property memorandum, we usually have our clients make what we call a special stuff list. And we usually have them describe that item and then the person that's going to get it. And as David mentioned, lots of times it's not monetary in nature. Sometimes it can just be sentimental in nature, but hugely important that you make sure that the right people get your special stuff. Of course, you don't have to put your couch on there, your TV, or things that you don't really care about, but it is important. I've seen lots of people fight over sentimental things. So hopefully you can avoid that in your family using that personal property memorandum. Dave, what are some of these special circumstances that might require our special attention?
It's a short list.
Okay. As you can see, you guys can read this list, but these are some of the things that we can protect you from if you put together a proper estate plan. Things like we can help make sure that all your children get the share that you want them to get. Lots of our clients are on their second marriage, and they have kids from, the first marriage, kids from the second marriage. It looks like the Brady Bunch lots of times. And, we want to make sure that the assets go to the right kids. Lots of times you have minor children. We don't want to give minor children a ton of money. I mean, that could be hugely harmful to them. Talking about passing our values to future generation. David gave us a good example with the Vanderbilts and the Rothschilds. So through your estate planning, you can also pass on some of your values. We have lots of clients that do things like, match what a child earns on a W-2, or some other things, or maybe they pass some of the assets out at different periods of different ages, maybe a third at when they're 30 and half at when they're 40 and the rest when they're 50. Those ages can vary. But some of our clients have special needs or supplemental needs beneficiaries, and we have to make sure, you definitely want to make sure that your trust or your estate plan is structured correctly, so you don't cut any of those special need beneficiaries off from any kind of government funding that they might be able to receive. We mentioned in here remarriage protection. That's a hugely important one. Lots of our clients, one of the spouses might go first, and what if that surviving spouse gets remarried and decides to totally change your estate plan? Well, you can put remarriage protection into your current estate plan to prevent a spouse from doing that. Such things like requiring that spouse get a prenuptial agreement if they get remarried and they still want to have access to those assets. And then several other things on here. It's hugely important, if you have a closely held business, that you include provisions in your estate plan about how that business will be dealt with. Who does it go to? Who runs it? Do we sell it? Do we keep running it? If you're going to sell it, who are some of the people that you might contact who might be interested in buying it? Just documenting all those things is so important. Lots of our clients have out-of-state real estate. They have real estate in other states, or maybe even real estate in foreign countries, and that's hugely important to deal with that as well in your estate plan. And then we talked a little bit about the estate tax and the generation skipping tax. Affects relatively few people, but if you're in that situation, definitely want to seek out a professional who can help you address the estate tax and the GST tax. Here's an example of a basic estate plan for a married couple. And you can see at the top that we have the revocable living trust, and we talked a little bit about that, but I'm a huge fan of the revocable living trust. It's just, think of it like a box and you're putting all your assets in it. You still control them. You can put your hand in the box and pull things out and put things in. But Dave's going to talk a little bit about that in an upcoming slide. But if you can do that, a creditor can do that as well. So a revocable living trust doesn't give you any creditor protection at all. We talked a little bit about some of these other documents that you want to have in place: a durable power of attorney, advanced directive, or a living will. And you can see that this revocable trust enters what they call kind of an administrative trust when one of the spouses dies. And that's just there is some administration that has to happen, right? I mean, you might have to collect the death benefit on insurance proceeds. You might have accounts that are at different places that you have to kind of aggregate. Things might have to get sold. You can see on here the personal property memorandum that David mentioned. That's a document that we stress that all people have, or all of our clients have. And then you can see the pour over will too. The pour over will, once again, is the legal backstop in case we didn't get everything lined up with your trust, or you forgot to tell us about the $100,000 CD that you had, and then you get hit by the bus. So that would have to go through probate, but your will would say, please dump it into my trust or pour it into my trust. So it would eventually get into your trust. And then after the administrative period, we'll kind of get down to the bottom of this. This one trust could get split up into a family trust, and I believe on the other side there's a marital trust. So those two trusts just basically work together so that there's no estate tax due at the death of the first spouse. You can see, so that's just a tax efficient estate plan, and it's a very, very good foundational estate plan. Something I'd recommend that everyone have in place. And you can see then upon the death of the second spouse, this trust is going to pass out to children, but that could be any beneficiaries. Lots of our clients don't have kids. They want it to go to nieces and nephews, or potentially even charities, right? So your beneficiaries can be whoever you want. And when you think about your estate plan, you get to design your estate plan. however you want to design this plan, I promise you that your lawyer can help you implement that plan. You just have to have a pretty good understanding of where you want your stuff to go, and then that lawyer can help you get it there. What do we got next, Dave? Oh, we're going to advanced estate planning.
So this is one of the areas that I enjoy talking about. So just from there's a lot of different moving targets here, all of which have certain benefits when you're looking at moving up from just having a basic estate plan, ideally with a fully funded revocable trust. Like Todd said, a revocable trust, anything that you can revoke, a creditor can revoke. So the revocable trust does not provide any asset protection planning during the grantor's lifetime. It's only after the lifetime, which means you got to pay a big price for it to become irrevocable, which then the creditor protection can kick in if the trust is drafted properly. But a couple of other asset protection tools out there just to keep in mind, one being the irrevocable life insurance trust. This removes the death benefit of a life insurance policy from being in your taxable estate. And like Todd said, not a lot of people have had to worry about a taxable estate, but that may change, starting in 2026. When you have life insurance of several $1 million and you have a taxable estate in combination, that pushes you over that soon to be lower exemption amount. Any life insurance you do transfer into your life insurance trust today has to be there or you have to live for 3 years. Otherwise, that life insurance is pulled back in your taxable estate. So generally that's intended to eliminate, any deathbed transfers of life insurance out of somebody's life estate. But that does not apply to any newly acquired life insurance. Another type of trust that allows you to pass that wealth in a protected environment on to future generations is typically what is called a dynasty trust. It is more specifically, it's a trust that has utilized the generation skipping transfer tax exemption. Keep in mind that if you just have a trust in it, you avoid estate tax at the first generation, and that trust continues for the next generations. It's not necessarily outside of the taxable estate of the future generations, unless you have exercised your generation skipping transfer tax exemption. And like Todd mentioned, that's $13,610,000 this year. It'll go back down to that inflation adjusted $5 million amount in 2026. Another type of asset protection to think about or advanced estate planning is a charitable remainder trust or a charitable lead trust. In addition to some type of family foundation. Those are generally for those clients who would like to make sure they don't pay an estate tax, but they would rather have that additional wealth go to their charities rather than I often describe it as the government's charities if you leave it to estate tax. So if given a choice, especially if you're over the estate tax exemption, I usually mention that you're a philanthropist, whether you know it or not, and you have a choice either to leave it to your own charities or the government's charities. So most people would rather keep it to themselves. And then another level of asset or estate planning, especially as a tool to transfer wealth during lifetime, is using variations of limited partnerships and limited liability companies, possibly having the units that are given away to the family members, be non-voting so that you can maintain control. And keep in mind, when you're in a taxable estate environment, it's control that is important, not necessarily ownership. So this is a popular tool, probably will become more popular here in a couple of years as a way to control wealth, but yet shift it down to the future generations without being subject to an estate tax. So when we look at how an advanced estate plan could look, and we put the life insurance policies over into a separate trust, we put other assets that we want to, either gift or pass on to family members while we maintain control. That's generally in a limited partnership. You have two different types of partners. One is called a limited partner or a general partner. And again, since control is important, it doesn't matter how much ownership that general partner has. So it could be as little as 1%, and there's still 100% control in all of the assets inside the partnership. That advanced plan may shifts the limited partnership interest over to the dynasty trust to get it out of the taxable estate and also exercise the generation skipping transfer tax. At the end of lifetime, again, if there's, the client has more than a taxable estate, you might put the amount that's subject to the exemption in the family trust, and push everything over to the marital trust, which zeroes out the taxable estate when the first spouse passes away. That family trust could continue downstream into future generations and qualify for the generation skipping transfer tax exemption, and potentially be merged with the other dynasty trust that was created during lifetime to give the limited partner interest to. And then the marital trust would, like I mentioned, will zero out the taxable estate when the first spouse pass away, but it may not zero out the taxable estate when the surviving spouse passes away. So that's where potentially having a series, one or more than one different types of charitable trusts. The reason it suggested here a layered testamentary charitable deed trust is these are done in stages where there's different time periods or different distribution percentages over a period of time, so that the family doesn't have to wait until much farther in the future to receive at least a partial distribution from that. And if you want to keep the charity within a tight control of the family, having that the charity of that charitable deed trust be a family foundation, which can then employ and engage the future generations to work back for that family and to carry on the family values. And as each of these layers terminate, that money then drops down into the dynasty trust and can someday maybe be merged with with the life insurance trust because it's fulfilled its purpose, and then ultimately down to where there's just one trust for all of the future generations after a couple's lifetime. So anyway, that's a little bit more of an advanced estate plan. When we deal with asset protection planning, we add then even another layer to this. So one would be if you have, if you're like most of our physician clients where we walk around, or they walk around with feeling like they have a bullseye on their chest, you may think about, looking at ways of owning your property that otherwise isn't protected from creditors, by setting up a certain type of entity. We call it here a charging order protection entity. There's 13 jurisdictions that that the only exclusive remedy that a creditor can have is what's called a charging order, which is basically like getting a lien against property. A creditor cannot take your interest if they have a lien or a judgment against you. They can't take your interest from in that LLC away from you unless you've committed some level of fraud or some other activity. But generally speaking, all they can get is this lien. And there's several states, Wyoming, Nevada, Delaware, and Oklahoma are popular in that area of offering that level of protection. If that's not enough asset protection, you can go up a notch and either do what's called an asset protection trust. So there are several states out there that have specific statutes that if you follow them, there's 17 states that have statutes that allow you to create a trust that's domiciled in that state. And generally speaking, you have to name a trustee in that state to serve as a trustee or a financial institution. So there's usually some requirements there. This is a relatively new creature, so a lot of people would say that they haven't yet been fully tested. But they do, statutorily, they are intended to protect against the grantor's creditors. If you want to go one step beyond that, which is what I consider somewhat of the ultimate asset protection, you may look at other jurisdictions outside the U.S. To set up an asset protection trust. That is just generally speaking, that's going to be an irrevocable trust that has a trustee other than you. If you serve as the trustee, you could be subject to being in contempt of court if a judge orders you to transfer all the assets of the trust, which you're allowed to do as a trustee, back to satisfy the creditors. So you rather than do that, you'd want to have an independent trustee, ideally domiciled in that country. And you then serve as what is called a trust protector, meaning that at a minimum, you have the right to fire that trustee for any reason and to replace them if you don't like what they're doing. And depending on the jurisdiction you're in, different jurisdictions have different requirements. I personally favor the country of Belize because there's a couple of big hurdles you have to get over. First of all, they don't recognize any foreign judgments. So that means a lawsuit brought in the U.S. where it results in a judgment and to come after assets owned by a Belize Asset Protection Trust, you'd have to bring that lawsuit all over again. And generally speaking, the juries are not going to be as favorable and less likely to be the plaintiff's peers, in Belize versus back in the U.S. The second advantage that I like about Belize is you got to put up a deposit just for the privilege of filing a lawsuit. So note, in the United States, it only costs a couple $100s to file a lawsuit. In Belize, you have to put up as a deposit the greater of $50,000 or 50% of the alleged damages. So as you can imagine, if you have just lost a $10 million lawsuit, the insurance company was way above your coverage limit. So they were willing to settle for pennies, but they left you high and dry. Now they start coming after your property. They find out that it's controlled by an asset protection trust in Belize. They knock on the door and say, hey, we're going to file this lawsuit. And first of all, they got to bring the lawsuit all over again. But secondly, in a $10 million judgment, they're going to have to put up a deposit of $5 million in cash. Well, that's going to chill about 99.99% of probably all lawsuits, because most of those lawsuits back in the U.S. have been brought by a lawyer working on a contingency. So it has a tremendous chilling effect to a plaintiff, especially. Hopefully they find this out in discovery and they decide it's better to settle before, rather than running up a bunch of expenses. But this is what I think is the ultimate settlement tool. If during discovery somebody finds out that all your assets are ultimately controlled by an offshore trust domiciled in a country like Belize, and then one level above that, you could have that trust own Belize LLC, which would allow you then to be the manager of that LLC, which ultimately owns all of the assets back in the U.S. that you wanted to own, that aren't otherwise protected.
Hey, David. David, isn't it true too that you're only really moving these assets a lot of times out of the U.S., before you have a problem? So you can keep a lot of these assets in the U.S. even if you're using a Belize trust and a Belize LLC. Is that what you were saying?
Yeah, what's important is the financial assets, for example, or the real estate that you own, are back in the U.S. It's just that they're titled in the name ultimately of this Belize LLC. So you can have several layers of entities in the U.S. that ultimately the chain of ownership goes back to the Belize LLC that's owned by the trust. And then one of the other nice features about a Belize LLC trust, which you can do this in any country, is you can put what's called a duress clause in the trust, which just merely means that if the trustee is put on notice, as if the other two limitations aren't enough, if the trustee is put on notice, they're required by the trust instrument to move the assets of the trust, which in this case is just the LLC, to another jurisdiction that has similar laws. So there's about 21 different countries that don't recognize foreign judgments. So you can play a pretty sophisticated, low-cost game of cat and mouse to keep a creditor away from your assets when you have this type of structure. And surprisingly, it's not all that expensive to set this up, whereas a couple of generations ago, it was pretty pricey. So it's now gotten pretty affordable. So like I mentioned, there's a couple of benefits for Belize. That also to consider. So when you're looking at that level of asset protection planning above and beyond, just having an LLC that's in a charging order protection state, a Belize asset protection trust coupled with a Belize LLC is generally going to give you one of the biggest bangs for the buck.
And hey, David, when do you want to put a plan like this in place?
Hopefully before a claim. You're put on notice that somebody's getting ready to file a lawsuit. So sooner rather than better, or later is better. But if you wait too late, you give the plaintiff a couple of remedies. One being, now they still got to find you in Belize, but there's a defense that they can exercise, or an affirmative defense of a fraudulent conveyance, which could cause the court to unwind that transfer of the assets into that trust.
So ideally, someone would put a plan like this in place when they had no problem at all, right? When they're not in any kind of trouble.
That's correct.
Yeah. Okay.
Yeah, or before getting married to that person you shouldn't have gotten married to. So anyway, so that's some background about asset protection trust. It is a fairly sophisticated tool, But again, it's gotten a lot more affordable over the last 20 years to put that in place. So I see it as a form of additional layer of liability protection, especially if you don't want to trust the insurance companies to always be there when something happens. So if we looked at a potential design of an asset protection trust, and we say, okay, we've got a couple of assets that each have liability to them. So let's put them either in a series LLC, which is a relatively new creature, or a domestic LLC. We want to have that trickle down and owned by a family limited partnership, where we have the general partner interest owned by an LLC that's owned by the revocable trust. And then we shift the limited partner interest over to the domestic or offshore asset protection trust. And where you can act as the trust protector, and then ultimately at the end of lifetime, that passes down to the generation skipping transfer tax. And then so that's the domestic version. You could do the same thing with the offshore, where you have the LLC in Belize, owned by a Belize asset protection trust that's ultimately also goes down. Usually these two work in tandem, so you have certain assets that you may not mind being owned by your limited partnership, so you can do some some wealth transfers out of your taxable estate. If you're under the exemption amount, you might just go ahead and go straight to having the offshore LLC and the trust. And at the end of the day, those, once it gets down to that bottom level, those trusts can be remerged together, just so you have one perpetual trust that goes on for the family members. So, Todd, any final comments on asset protection?
No, I think it's super important that everyone consider this and consider some type of asset protection plan sooner rather than later. David, as you mentioned, we see it's much better, much more sound to put it in place before you have any problems out there. And so I just encourage everyone to look at putting a plan in place before you need it.
Yeah, absolutely. Well, just talking about next steps and just wrapping things up, I just want to just share with you, if you haven't already heard, we have a process here and a model at Provident, and it's all described in a book called The Richest Doctor, which is available on the richestdoctor.com website if you're interested in learning more about it. It is a fiction of 4 physicians as they take a journey to reach financial independence. If you do work with us, we have a unique process that starts with a strategic tax blueprint, where we go through all of the tax planning ideas that we can come up with. If you like what you see, we have an onboarding and implementation of those strategies. And then our cornerstone of our services is that we circle back around at the end of every year and do a pretty deep dive on year-end tax planning. Election years are always interesting time periods, because we don't necessarily know who's going to get elected and what Congress is going to look like. But we'll know here in about a week. And to the extent that one of the candidates gets elected, you might want to go back to the webinar that we did a couple of weeks ago, where we talked about what their proposed tax changes would be. Keep in mind that presidential candidates aren't legislative entities, so they can't pass the laws, but they can certainly sign them into law if they do get passed. So just election years, and usually right at the end of the year, tax planning become very popular whenever you have a new candidate. If you are interested in learning more about how we might be able to help you at Provident, you can click on this QRC code. That'll put you in touch with Angie O'Day, who is happy to spend a 30-minute introductory call with you, just to talk about your situation and whether or not there's some things out there that we might be able to help you resolve. And then, like I mentioned, if you'd like to get a copy of the book, there's another QRC code. You can download the first 2 chapters for free, or if you'd like to go ahead and order the book, it just costs $4.99 plus shipping and handling, and that's available on the richestdoctor.com website. And then this last slide, we just would like to address any outstanding questions that anybody has in the audience. So, Crystal, I don't know if you have the list of potential questions.
Yeah, I have some questions. First one, how often should an estate plan be reviewed or updated?
Well, I can answer that one. I think it really depends. How's that for a good lawyer answer for you? But I think if it probably depends on your family situation and your assets, and maybe even changes in the law, right? But I'd say in general, for most people, you should do it every 3 to 5 years. There could be situations where people have, they're changing assets a lot, their family, lots of changes in their family, and they should sit down with their attorney every year. I promise your attorney will be happy to sit down with you and update your plan. So, but I'd say probably on average every 3 to 5 years.
Yeah, and I think the average, Todd, is what, about every 19 years when it's
Yeah.
usually when the first child is born and when the first child gets married and the couple sees who their new in-law is going to be, so they rush around and update their estate plan and make sure they're protected.
That's right. And I mean, when they do it every 19.6 years or whatever that number was, we find that a lot of plans don't really work the way they intended them to work. So definitely more frequently than once every 19.6 years.
Awesome. All right, just another one. Do estate planning laws differ between states? And what should I be aware of if I own property in multiple states?
Well, yes, estate planning laws do differ between states. So you're going to want to make sure that, whatever state you live in, that's probably or definitely where your estate planning documents should be based. And that's the laws that you should utilize for your estate plan. I think if you have property in multiple states, you should consider, using an LLC and maybe having that LLC owned by your trust. Maybe even consider an asset protection plan. But I think you definitely, if you have property in multiple states, you want to avoid probate, because you could get in a situation where you had to probate property in multiple states, and they call those ancillary probate proceedings. So I would 100% recommend you avoid that. Dave, do you have anything to add to that?
Well, and then just also maybe make a comment about people who have lived in community property states and they move to a separate property state, or heaven forbid, they move to Louisiana.
Yeah, very good point.
So there's different laws that tend to carry on. Even if you move residency, that the way that it could be taxed or treated for local law purposes may differ.
All right, thank you. And then just one more question I have from the audience. What are the main considerations for setting up trusts for children from different marriages?
I'd say, when you have children from different marriages, that you have to think about, well, obviously adds lots of complexity, but you have to think about what assets are going to which child. You have to ask yourself the question, are kids getting assets at the death of a first spouse? I have a lot of clients that it's a second marriage, and they feel pretty strongly about the kids getting some assets when the first spouse dies. So that's a consideration. You also have to think about the fact that, what if that surviving spouse gets remarried? And you have to think about, does the surviving spouse have the ability to change the estate plan? Because I think many times you don't want that to happen. You don't want that surviving spouse to be able to change the plan that you put together. Your kids might end up getting cut out of that deal. But Dave, what would you add to that?
Well, I think it's about as diverse as it is, when you look at, families and what they, ultimately who makes up their families. So it's not I don't think there's a one size fits all. I think it's really walking through, the fire drill of what would happen, when each spouse passed away, and what were the assets that are available. And is it more important to hold on to those assets for the surviving spouse, versus spreading them out to the kids? But there's not an easy answer to that. I think it really depends on, looking at all the potential outcomes and trying to make sure that the outcome that actually happens is the one that both husband and wife want.
Awesome. And that was the last question. So thank you for answering those.
Awesome.
Well, Todd, thank you very much for sharing your expertise on estate planning and asset protection planning today. And Again, if anyone is interested in learning more, feel free to reach out to Angie and schedule a call, and we will schedule an introductory call to get back or circle around with Todd.
Thank
So
you.
thanks again, everyone.
Thanks for joining us.